Washington Journal segment at this point as the Senate's about to gavel in. Quick reminder, you can see this and any Washington Journal program online anytime at cspan.org. Live to the Senate now as lawmakers will work on non-discrimination legislation for LGBT employees. A test vote on that and confirmation votes for a pair of judicial nominees will take place around 5:30 this afternoon. Now live to the Senate floor on C-SPAN 2.
The Senate will come to order. The Chaplain, Retired Admiral Barry Black, will lead the Senate in prayer. Chaplain.
Let us pray. Eternal God, help us to so live that the generations to come will know of your mighty acts. Today, give our lawmakers the singularity of heart to seek, find, and follow your will, so that their legacy will be exemplary. Lord, guide them in the path you have created, inspiring them with the potency of your powerful presence. May they trust you in times of adversity and prosperity, knowing that they will reap a productive harvest if they persevere. Keep them from underestimating the power of your great name. And Lord, we ask that you would sustain the victims and families of the Los Angeles airport shooting. We pray in your merciful name. Amen.
Please join me in reciting the Pledge of Allegiance to the flag. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The Majority Leader.
Mr. President, I ask that, I just tell the Senate that following my remarks, the Senate and those of Senator McConnell, the Senate will resume consideration of the motion to proceed S. 815, the Employee Non-Discrimination Act. At 5 o'clock today, the Senate will proceed to vote in executive session to consider the nominations of Gregory Woods to be a United States District Judge in New York and Deborah Brown to be a U.S. District Judge in Mississippi. That after debate on those two nominations, at 5:30 there'll be up to 3 roll call votes. I would hope that one of them can go by voice, but we'll have to wait and see. Confirmation of the Woods and Brown nominations, and then cloture vote on the motion to proceed to end the Employment Non-Discrimination Act. Mr. President, Springfield, Massachusetts police officer Michael Carney fought for 2.5 years to get his job back, and he won. After he took medical leave of absence, Springfield officials refused to reinstate Officer Carney because the veteran police officer had revealed he was gay. But Officer Carney was determined to return to the force. Because he lives in Massachusetts, one of only 17 states that protect employees against discrimination based on sexual orientation or gender identity, Officer Carney is now back on the job, serving and protecting the people of Springfield, Massachusetts. I'm also pleased to say Nevada law also includes robust protections against this type of discrimination. Officer Carney testified before the House of Representatives in 2007 and shared his story. Mr. President, this is what he said. I'm a good cop. If I've lost 2.5 years of employment fighting to get that job back because I'm gay. I never would have been able to do that had I not lived in Massachusetts or in one of the handful of other states that protect employees from discrimination. Sadly, Mr. President, not everyone is able to fight back like Officer Carney. In 33 states, lesbian, gay, bisexual, and transgender people can be fired or harassed just for being who they are. West Virginia coal miner Sam Hall was terrorized by his co-workers for 7 years because he was gay. Mr. Hall just wanted to make a living, but supervisors told him he would have to endure the persecution if he wanted to keep his job. West Virginia is one of 33 states with no protections against this type of oppression. That's why, Mr. President, I so admire Joe Manchin for recognizing that this is an issue that's important to everyone. Patchwork of state laws that excludes tens of millions of Americans from basic protection against discrimination is simply not good enough. It's time for Congress to pass a federal law that ensures all Americans, regardless of where they live, can go to work unafraid to be who they are. As long as hardworking, qualified Americans can be denied job opportunities, fired or harassed because of their sexual orientation or gender identity, all workers are at risk. This week, the Senate will begin debate on the Employment Non-Discrimination Act, which would simply afford all Americans the same protections from discrimination based on prejudice. In fact, 4 out of 5 Americans mistakenly believe that these protections already exist. 2/3 of Americans, including a majority of Republicans, support federal protections against discrimination based on sexual orientation and gender identity in the workplace. But once again, Republicans in Congress are out of step with Republicans in the rest of the country. House Speaker John Boehner this morning said that he does not support this legislation. But the Speaker should take his cue from 56% of Republicans nationwide who support ENDA and bring this legislation up for a vote. Corporations also agree non-discrimination policies are good for business. Most Fortune 500 companies already prohibit this kind of persecution. And more than 100 of the nation's largest businesses, more than 80 national civil rights, labor, religious, civic, and professional organizations, and faith leaders from many denominations have spoken out in support of the Employment Non-Discrimination Act. But there's more, much more, and a more important reason to support this legislation than popular support. It's the right thing to do. Here's what Harvey Milk, the murdered California politician, gay rights activist, said, and I quote, "It takes no compromise to give people their rights. It takes no money to respect the individual. It takes no political deal to give people freedom. It takes no survey to remove repression." Close quote. All Americans, regardless of what they look like, where they live, or who they choose to love, deserve to be treated with the same respect and dignity while they earn a living. An employee should not be judged on matters that really are unimportant, Mr. President. We're talking about fairness. Employees should be judged on the quality of their work and on their talents and on their performance, and not on their sexual orientation or their gender identity. So, Mr. President, I urge my colleagues to vote tonight supporting the legislation that 81% of Americans approve, to begin debate on a bill that would affirm the equal rights and freedoms of every American, and to do so simply because it's the right thing to do. Mr. President, I would like a new position in the congressional record dealing with health care. Mr. President, yesterday I read an excellent column in the New York Times by Nicholas Kristof, a complete text of which I ask unanimous consent that it appear in the record.
Without objection.
Mr. President, the editorial tells the story of a number of things, but of one Richard Streeter, a truck driver who is very, very, very ill with colon cancer. Why? Because he couldn't afford insurance, couldn't afford health insurance. Kristof writes, and I quote, "The biggest health crisis in America right now is not the inexcusably messy rollout of Obamacare. No, far more serious is a kind of catastrophe facing people like Richard Streeter." Mr. Streeter is a resident of Eugene, Oregon. His problem isn't Obamacare, but a tumor in his colon that is going to kill him unless there's a miracle. He could have been treated had he had health insurance. For him, Obamacare didn't come quite soon enough. Kristof's column is an important reminder that the rollout of Obamacare is about more than an effective website. It's about saving lives, lots of lives. Kristof reminds Republicans that they should have empathy for the nearly 50 million Americans without insurance who play health care roulette every day as a result. So he urges them, the Republicans, to remember that every 20 minutes an American dies. Why? They lack health insurance. Would the chair announce the business of the day?
Clerk will call the roll.
Mr. Alexander.
Plans for the Senate today include work on a non-discrimination legislation for LGBT employees. A test vote on that and confirmation votes for a pair of judicial nominees will take place about 5:30 this afternoon. Over on our companion network, C-SPAN, live coverage of the public hearing from the Privacy and Civil Liberties Oversight Board hearing. The focus is foreign surveillance for the afternoon session. And then on C-SPAN 3 this afternoon, U.S. News and World Report host an event on the health care law and challenges facing hospitals. Former Republican Senate Majority Leader Bill Frist, who's also a surgeon, will take part in that, along with the heads of the Texas Medical Center and the Cleveland Clinic. That's live at 3 p.m. Eastern on C-SPAN 3.
Mr. President,
Senator from Iowa.
I ask that further proceedings on the quorum call be dispensed with.
Without objection, under the previous order, the leadership time is reserved. Under the previous order, the Senate will resume consideration of the motion to proceed to S-815, which the clerk will report.
Motion to proceed to calendar number 184, S-815, a bill to prohibit employment discrimination on the basis of sexual orientation or gender identity.
Senator from Iowa.
Mr. President, first, I ask unanimous consent that Sergio Plaza and Lauren Erickson of my staff be granted floor privileges for the duration of today's session, and that Katrina Rogachevsky be granted floor privileges for the duration of this week.
Without objection.
Well, Mr. President, today marks another step forward in the progress of the United States of America in making sure that all of our citizens are treated fairly and equitably under law, that each citizen of this country will know that he or she cannot be discriminated against because of race, religion, sex, national origin. That's all covered in the Civil Rights Bill of 1964. Then in 1990, I was proud to stand here at this very desk when we took another step forward, when we said that we're going to extend civil rights to cover people with disabilities. Today, I stand here to mark another step forward, when we declare that we'll have the vote later on proceeding to the debate, but we start it now to end discrimination in employment because of a person's sexual orientation. It is a huge step forward, one too long in coming. One too long in coming. I was here in 1996 when we voted on ENDA, the Employment Non-Discrimination Act, the bill that's now before the Senate floor. And we lost it by one vote, 50 to 49. That was a dark day. We've been trying to get it up ever since, and finally we've done it. And I'm proud to say that we got it through our committee, the Help Committee, this summer on a strong bipartisan vote, and now we have it now before the Senate. And so people should understand this is a momentous day. Again, in the development in our country of ensuring that every person is recognized for their individual worth and for what they contribute to society, not for what the color of their skin or their race or their religion or national origin or whether they have a disability. Today we say, and also we're going to make sure you can't be discriminated against because of your sexual identity or who you love. ENDA, the Employment Non-Discrimination Act. So it's been 17 years. Ted Kennedy was chair of this committee. He brought it to the floor in 1996. It was just, again, one vote shy of passage. In the meantime, in those 17 years, the attitudes in this country have changed dramatically, about the rights of gay, lesbian, bisexual, and transgendered Americans. I think in a nutshell, the vast majority of Americans believe that individuals ought to have the right to earn a living free from discrimination, to be judged on their performance in the workplace based on their talent and their ability and their qualifications. Interestingly enough, since 1996, 17 states, including my state of Iowa, have passed legislation that includes basic employment protections for all LGBT Americans. I will use that acronym or those letters to explain that lesbian, gay, bisexual, and transgendered Americans. 88% of Fortune 500 businesses have included protections in their non-discrimination policies, as have the majority of small businesses. Over 100 major businesses, including pharmaceutical companies, technology companies, banks, manufacturing companies, chemical companies, have announced their support for this bill. In fact, there's polls that show that 8 out of 10 Americans already believe that discrimination against people because of their sexual orientation is already illegal, that it's illegal to fire someone for being gay, for example, or for being lesbian. So why are we here today? 23 years ago, I stood here at this desk as the manager of the bill, the Americans with Disabilities Act, again to extend non-discrimination clauses, civil rights bills to people with disabilities. A lot of people at that time said, what's the problem? What's the problem? Well, here's the problem in a nutshell. Let's say that you are a person of color. Let's say you're an African American. Or it could be a woman. You could be Jewish or Catholic or anything else. And let's say that you went down to apply for a job for which you were fully qualified. And a prospective employer said, nah, I'm not going to hire any African Americans. I want black people working there. No, I'm not going to hire you. You're Jewish. Get out of here. You know what you could do? You could turn right around, walk out the door, and go down to the courthouse, and the courthouse door is open for you. You go into that courthouse and take that case to court. 23 years ago when I stood here, I said at the time that up until that day, up until the President signs into law, if you're a person with a disability and you wheeled your wheelchair in there and you were qualified for the job and the prospective employer said, get out of here, I don't hire cripples, and you went down to the courthouse door, it was locked. The courthouse door was locked. You had no recourse under law for the violation of your civil rights. That is true today of gays, lesbians, bisexual, and transgendered Americans. They can be fired just because of that. They go down to the courthouse door, it's locked. They have no recourse under law. Now, as I said, 17 states have state laws. Some municipalities have municipal laws. But the vast majority of Americans live in states in which there is no civil rights law governing LGBT people. The majority of Americans, more than 56%, live in states where it's perfectly legal to fire someone or to refuse to hire a person because of who they are, lesbian, gay, bisexual, or transgender citizen. They have no recourse under law. As I said, most people in America think that the people are covered. You can't discriminate against someone because of that. But the fact is, it's still perfectly legal to do so in most states in the United States. As I said, I think we've changed quite a bit in the 17 years since we last considered this bill. That last vote, 49 to 50, lost by 1 vote. No amendments. No amendments. And a majority of senators would have been enough at that time to pass it. All we needed was 1 more vote. And I remember then Vice President Al Gore was sitting in the chair up there, Mr. President. But we were 1 vote short. Today, however, as times have changed, we know you need 60 votes to pass things here now. Just think about that. 17 years ago, 51 votes would have passed this bill. Now you've got to have 60 votes. But I won't get into the necessity of having to change the rules of the Senate. But we need 60 votes before we can even bring the bill up. It is a tribute to the leadership of the bill's sponsors, Senator Jeff Merkley and Senator Mark Kirk, that we have now reached 60 votes. Actually, as of just last week, we only had about 57, 58. Then another person came on, and another person this morning announced Senator Heller of Nevada announced his support for the bill, and that puts us at 60 votes. So we have the 60 votes, and I'm predicting, Mr. President, we'll get more than 60 votes. Once you reach that critical mass, I think people here will understand that this is a step, another step in the direction of opening America up and making our society more inclusive rather than exclusive. Senator Kirk, who is managing the bill for the minority, has been a supporter of this legislation before he was elected to the House. Senator Merkley, on our side, who is the sponsor of the bill, was the leader of this effort in the state of Oregon when he was in the Oregon State Legislature. So both of them, one Republican, one Democrat, have been champions of this bill since before they even came here to Congress. They both played a critical role in getting it into our committee. And even though Senator Merkley left our committee to join the Appropriations Committee, he always kept on top of this. And with their help, we voted it out of our Help Committee, as I said in July, a strong bipartisan vote, 15-7. 15-7. And I want to thank the present occupant of the chair, distinguished senator from Connecticut, for all of his help and support for getting this bill through. And we had the support of 3 members, I said, of the minority. 15-7 vote. It was a great vote. So, Mr. President, despite the passage of laws at the state and local levels, discrimination in the workplace continues to be all too real. 42% of lesbian, gay, and bisexual workers report having experienced some form of discrimination at work. Even with the progress that's been made at the state and local levels that I mentioned, too many hardworking Americans, whether employed by private companies or by public entities, are being judged not by their ability and their qualifications, but by their sexual orientation or gender identity. Consider the example of Michael Carney, who was denied reinstatement as a police officer 3 times before successfully using the protections of state law to get his job back. This is a job in which he has now served with distinction for many years. Or consider Sam Hall, a West Virginia miner who suffered destruction of property and verbal harassment from his coworkers because of his identity as a gay person. Sam is one of those millions of Americans who currently have no legal recourse without this law. Discrimination against transgendered Americans is even more common, with 78% reporting harassment at work. I was fortunate enough to hear from Kyler Brodus as a witness at our Help Committee hearing on the bill last year. Kyler faced intense harassment at work as he transitioned from female to male. He has never fully recovered financially from the loss of his well-paid position. Allison Robinson also provided written testimony to the committee regarding the painful separation from her family that she endured because of financial hardships while she searched for her first job as an openly transgendered female. Again, too many of our fellow citizens are being judged not by what they can contribute to the workplace, but by who they are and whom they choose to love. Unfortunately, we can cite countless cases of bigotry and blatant job discrimination based on sexual orientation or gender identity. Equal opportunity is not just an abstract principle or a matter of statistics. Every day, decent, hardworking Americans are being hurt by this form of discrimination. So it's been almost 50 years since we first took steps to eliminate discrimination at work, 23 years since we passed the Americans with Disabilities Act to eliminate discrimination against people with disabilities. And we still have a long way to go. But our country is a far better place, far better, because of laws against discrimination based on race and sex and national origin and religion and age and, yes, disability, among others. So it is time, at long last, for us to also prohibit discrimination on the basis of sexual orientation and gender identity. Such discrimination is fundamentally wrong and cannot be tolerated any longer in our country. Lesbian, gay, bisexual, and transgendered Americans deserve the same civil rights protections from discrimination as all other Americans. This bill will accomplish that. It will say to millions of LGBT Americans that they are full and welcome members of our American family, and they deserve the same civil rights protections as every other American. Now, the bill is very simple. It's very clear. It states that private businesses, public employers, labor unions, cannot make employment decisions, that is, hiring, firing, promotion, or compensation, because of a person's actual or perceived sexual orientation or gender identity. There are exemptions for small businesses and religious organizations, and the current rules that are applicable to the armed forces are not affected. The bill expressly prohibits disparate impact claims. I want to repeat that. The bill expressly prohibits disparate impact claims. It is modeled on Title VII of the Civil Rights Law. The law has been in place, as I said, since 1964. This bill also incorporates many suggestions from members of both sides, Republicans and Democrats, on our HELP committee. And I'm glad we could work on a bipartisan basis to improve the bill and to get it through our committee. ENDA, as it's known, the Employment Non-Discrimination Act, has unprecedented support from major American businesses. Mr. President, I'd like to enter into the record a letter of support from over 100 businesses, among them including Dow Chemical, General Electric, Hilton Hotels, GlaxoSmithKline, Chevron, Wells Fargo, Marriott Hotels, Coca-Cola, Cisco, Kaiser, and on and on. I'd like to submit this list of over 100 companies in America that support the passage of the bill.
Without objection.
In the course of our hearings on this bill, we heard from executives of Nike and General Mills, among others, asked why they had chosen to implement strong non-discrimination policies themselves. The Nike executive testified, and I quote, that ENDA is good for business because teams thrive in an open and welcoming work environment where individuals are bringing their full selves to work. So the bill we're debating today specifically protects religious liberty with a substantial exemption that allows specific religious organizations to continue to take sexual orientation and gender identity into account when making employment decisions in their religious organizations. ENDA, I might point out, is supported by 60 faith-based organizations, including congregations and organizations ranging from the Presbyterian Church of America, the Episcopal Church, the Progressive National Baptist Convention, the Union of Reform Judaism, the Union Synagogue of Conservative Judaism, the Islamic Society of North America, and many others. Polls, as I said, show a lot of different things. Polls show that 76% of American Catholics support basic workplace protections for LGBT workers. Almost 70% in that poll of evangelical Christians support LGBT employment protections. So there's overwhelming support for this bill, as I said, amongst people of faith and religious-based organizations. So again, I acknowledge the leadership of Senator Kirk, the bill's lead sponsor, Senator Jeff Merkley of Oregon, again, who has championed this bill and without whom, I dare say, we would not be starting this debate today. In addition, we are fortunate that the lead Democratic sponsor of the bill in the House in previous Congresses is now a member of the Senate and a member of our HELP committee. And I hope that she will soon be able to say that she helped pass this bill in both the House and the Senate, and that's Senator Tammy Baldwin of Wisconsin. So, Mr. President, I look forward to the vote later today when we will vote to proceed to this bill. As we all know, under the rules of the Senate, after cloture is invoked, we'll have up to 30 hours of debate. And then the bill will be on the floor and open. We've had several amendments that were filed in committee that members of the Health Committee reserved to try to put it here on the floor. So I'm confident that we can work through those if they are offered again. I would hope that all amendments that are offered will be directed at improving this important civil rights legislation. And I hope that amendments that are focused on unrelated matters can wait for another time, another day, perhaps when that issue is on the floor. This is just too important. This major step forward in expanding our concept of civil rights laws, too important to be dragged down by spurious amendments that have nothing to do with the bill whatsoever. And so I hope we don't get bogged down on that. Mr. President, as I said, it's been a long time coming for this bill. When you think about it, 17 years ago we voted on it, lost by one vote. Attempts have been made periodically to get it back up again, and it just never happened. But now we do. And we reported it out of committee, as I said, with a good bipartisan vote. It's a critically needed bill. It's common sense legislation. It has overwhelming support from corporate America, from religious groups, from small and large businesses all across the country. As I said, 8 out of 10 Americans already think it's the law. So let's make sure that those 8 in 10 Americans who already think it's a law will now know that it really is the law. And we can pass it, send it to the House. Hopefully the House will pass it and the President will sign it into law as soon as possible. No American, no American, no American should be turned away or having to fear a loss of their job or their means of support, or fear not being hired even though they're eminently qualified, for any reasons other than their ability to do that job. People shouldn't be fired. They shouldn't be discriminated against in hiring because of color of skin, race, religion, sex, national origin, disability. That's already in the law. Now we put this next piece in place. No one should be denied a job, an opportunity to work because they're gay, lesbian, bisexual, or transgendered. That's what this bill does. I encourage all senators to join with us in passing this important civil rights legislation, continuing our nation's advance toward freedom and inclusion for everyone in our society. So let's say this is a bright day for America. We finally bring it here. As I said, we'll have the vote later today. We have 60 people that have said they'll vote for it. I hope we have more. And sometime later this week, I don't know if we're going to use the 30 hours or not, hopefully sometime this week we can finally pass it. Finally pass it. It will be, as I said, I think this week will be one that will be an uplifting week. An uplift. We've had a lot of problems around this place in the last couple of months. And I know that, read the polls, I think members of the Congress, I say both the House and the Senate, I think in the general public we're probably about as popular as a toothache right now. But this week we can show the American people that we can come together and we can lift our eyes above the haze and the smoke and the horizon, and we can make this country a better place for all by passing this bill. Let's do this, and let's bring to the American people what they think they have already and what they know they want, and that is a society free of discrimination. Mr. President, with that, I yield the floor, and I note the absence of a quorum.
Clerk will call the roll.
Mr. Alexander. say aye.
Senators have been debating a non-discrimination bill for LGBT employees. The White House just released a statement about the bill, saying that the president supports it because he would establish lasting and comprehensive federal protections against employment discrimination on the basis of sexual orientation or gender identity. The statement goes on to say that this bipartisan legislation is necessary to ensure that strong federal protections exist for lesbian, gay, bisexual, and transgender workers no matter where they live. A test vote on the bill is expected later today, along with confirmation votes on a pair of judicial nominees, which will take place at around 5:30 this evening. As we wait for a senator to speak, a briefing from today with Attorney General Eric Holder on a settlement with a drug company.
Well, good morning. And thank you all for being here. I'm joined by the Associate Attorney General, Tony West, the Assistant Attorney General for the Civil Division, Stuart Dellery, the United States Attorney for the Eastern District of Pennsylvania, Zane Meminger, the U.S. Attorney for the District of Massachusetts, Carmen Ortiz, First Assistant United States Attorney for the Northern District of California, Brian Stretch, and the Deputy Inspector General for Investigations at the Department of Health and Human Services, Gary Cantrell. We are here today to announce that Johnson & Johnson and 3 of its subsidiaries have agreed to pay more than $2.2 billion to resolve criminal as well as civil claims that they marketed prescription drugs for uses that were never approved as safe and effective, and that they paid kickbacks to both physicians and pharmacies for prescribing and promoting these drugs. Now, through these alleged actions, these companies lined their pockets at the expense of American taxpayers, patients, and private insurance industry. They drove up costs for everyone in the healthcare system and negatively impacted the long-term solvency of essential healthcare programs like Medicare. This global settlement resolves multiple investigations involving the antipsychotic drugs Risperdal and Invega, as well as the heart drug Natracor and other Johnson & Johnson products. Now, the settlement also addresses allegations of conduct that recklessly put at risk the health of some of the most vulnerable members of our society, including young children, the elderly, and the disabled. In the criminal information that was filed today, we allege that Johnson & Johnson subsidiary, Janssen Pharmaceuticals Incorporated, violated the Federal Food, Drug, and Cosmetic Act by introducing Risperdal into the market for unapproved uses. Now, in its plea agreement, Janssen admits that it promoted this drug to healthcare providers for the treatment of psychotic symptoms and associated behaviors exhibited by elderly, non-schizophrenic patients who suffered from dementia, even though the drug was approved only to treat schizophrenia. In separately filed civil complaints, we further allege that both Johnson & Johnson and Janssen Pharmaceuticals promoted Risperdal and Invega to doctors and to nursing homes as a way to control behavioral disturbances in elderly dementia patients, in children, as well as the mentally disabled. Now, the companies allegedly downplayed the serious health risks that were associated with Risperdal, including the risk of stroke in elderly patients, and even paid doctors to induce them to prescribe these drugs. As part of the scheme, the companies allegedly paid kickbacks to the nation's largest long-term care pharmacy, whose pharmacists were supposed to be the gatekeepers to provide an independent review of patient medications. Now, instead, at the company's behest, the pharmacist allegedly recommended Risperdal for nursing home patients who exhibited behavioral symptoms associated with Alzheimer's disease as well as with dementia. Now, this alleged conduct resulted in government health care programs paying millions of dollars in false claims for these drugs. Now, to resolve allegations stemming from the improper promotion of Risperdal, Janssen Pharmaceuticals will plead guilty to misbranding Risperdal and has agreed to pay $400 million in criminal fines as well as forfeitures. Johnson & Johnson and Janssen Pharmaceuticals have further agreed to pay over $1.2 billion to resolve their civil liability under the False Claims Act. And Johnson & Johnson will pay an additional $149 million to resolve claims relating to alleged kickbacks to a long-term care pharmacy. Now, in addition to these claims, we allege that Johnson & Johnson, as well as its subsidiary, Sios Incorporated, promoted the heart failure drug Natracor for off-label uses that caused patients to submit to costly infusions of the drug without credible scientific evidence that it would have any health benefit for those patients. In a separate matter that was resolved in 2009, Sios pleaded guilty to misbranding Natracor and paid a criminal fine of $85 million. To resolve current allegations associated with the settlement that we announced today, the companies have agreed to pay an additional $184 million. Now, this significant settlement was made possible by the relentless investigative and enforcement efforts of dedicated men and women serving as part of the Healthcare Fraud Prevention and Enforcement Action Team, or HEAT, which Health and Human Services Secretary Kathleen Sebelius and I launched more than 4 years ago to recover taxpayer dollars, to keep the American people safe, and to aggressively pursue fraud and misconduct whenever and wherever it is found. Put simply, the alleged conduct is shameful, and it is unacceptable. It displayed a reckless indifference to the safety of the American people, and it constituted a clear abuse of the public trust, showing a blatant disregard for systems and laws designed to protect public health. As our filings make clear, these are not victimless crimes. Americans trust that the medications prescribed for their parents and for their grandparents, for their children, and for themselves are selected because they are in the patient's best interest. Laws enacted by Congress and the enforcement efforts of the Food and Drug Administration provide important safeguards to ensure that the drugs are approved for uses that have been demonstrated as safe as well as effective. Efforts by drug companies to introduce their drugs into interstate commerce for unapproved uses subvert those laws. Likewise, the payment of kickbacks undermines the independent medical judgment of healthcare providers. It creates financial incentives to increase the use of certain drugs, potentially putting the health of some patients at risk. Now, every time pharmaceutical companies engage in this type of conduct, they corrupt medical decisions by healthcare providers. They jeopardize the public health, and they take money out of taxpayers' pockets. This settlement demonstrates that the Departments of Justice and Health and Human Services, working alongside a variety of federal, state, and local partners, will simply not tolerate such activities. No company is above the law, and my colleagues and I are determined to keep moving forward, guided by the facts and the law, using every tool, resource, and authority at our disposal to hold these corporations accountable, to safeguard the American people, and to prevent this conduct from occurring in the future. Now, this announcement marks another step forward in our strategic, comprehensive, and effective approach to fraud prevention. We can all be encouraged by the actions that we have taken and by the results that we have obtained in recent years. But we cannot yet be satisfied, and that's why here in Washington and across this country, this critical work will continue. Now, I'd like to thank everyone who made this settlement possible. And in particular, I want to recognize the leaders, the prosecutors, the trial attorneys, the investigators, and the staff at the Civil Division here in Washington, as well as our United States Attorney's offices in Philadelphia, in Boston, and in San Francisco. I'm grateful for the committed efforts of our partners at the Department of Health and Human Services, and particularly in the Office of the Inspector General, as well as the Food and Drug Administration and many other federal agencies that contributed to this outcome. And I want to thank each of the state attorneys general and Medicaid fraud control units across this country who contributed to this investigation. We'd be happy to take any questions that you have at this time, and I guess what I'd like to ask is maybe direct at least the initial questions at the announcement that we have just made.
Over what period of time were these drugs improperly administered, and how many patients received them, took them?
With regard to the number of patients, I don't have that figure. With regard to the False Claims Act allegations, with regard to Risperdal, it covers a 10-year period from 1999 to 2009. With regard to the criminal misdemeanor charge, it covers a little over a 1-year period. It starts in March of about 2002 and carries on until December of 2003. It covers a time period where the Risperdal label was limited to schizophrenia.
Are there any cases where the risk actually turned into actual harm? So it wasn't just that these patients were put at risk, but that they actually had some sort of harmful effects?
With regard to the evidence in this case, we don't have evidence of actual patient harm. What we do have are statements and representations that indicate that risk was being minimized with regard to the use of the product in the elderly, especially with regard to the risk of stroke, also with regard to diabetes, things of that nature. And it's incumbent on the government to take a look at these type of behaviors to make sure that we're prosecuting these cases appropriately to ensure patient safety.
Just to add to that, one thing that ties the pieces of this case together, the fact that all of it relates to conduct that undermines the regulatory system that's been set up to protect the safety of the medicines that we take. And so part of it relates to activities of the company in marketing efforts, but also the Omnicare portion of the case relates to kickbacks that were paid, which have the potential to undermine the medical judgment of medical professionals making decisions about individual patients. And we think it's important that we enforce this program that the Federal Food and Drug Administration administers to safeguard medical judgments that are made across the country.
Are there any remaining claims that the government has against Johnson & Johnson related to these goods, to these drugs? Or does this settle all the claims that the government has against the company?
This is a global resolution, and with regard to the drugs that are announced, this resolves the matter based upon the evidence that we evaluated and made significant determinations as to what the appropriate result would be, and we've now reached a global resolution so that we can move on to other cases.
How many physicians were involved in taking kickbacks, and how much was paid to them?
We do not have that specific number, and a lot of what had occurred was that J&J as well as Janssen paid the kickbacks to Omnicare, and Omnicare actually in 2009 settled charges against it in which it had accepted kickbacks from J&J, and it had also paid kickbacks to to nursing homes that were utilizing Omnicare, the pharmacy, for its prescription drugs. And the kickbacks were really in the form of rebates that went to Omnicare, as well as fees that were supposedly to pay for data, and also payments were disguised to look like educational funding, in particular for pharmacists who were used to induce doctors to prescribe certain medications, and in particular Risperdal, to seniors in nursing homes.
So no actual individual payments were made to doctors? They were made as sort of a blanket payment?
I believe that payments went to the doctors in the basis of like speaking fees for certain presentations that were made and certain meetings that were attended.
Just to reiterate the question that was already asked, if we're looking for a case where someone has either died or an elderly patient has been injured because of this, you don't know of one. Is that accurate?
I believe that's correct. Yes, that is, sir.
There was
A decision from the Second Circuit last December in a case called U.S. versus Coronia that held that the First Amendment basically protected off-label marketing by drug companies. Can you explain to us if you think that decision was wrong? Why didn't the department try to pursue that elsewhere? And are you pursuing these cases, despite that, or you still think those laws should be enforced anyway?
Well, I believe that in that particular case, the conduct that it was looked at, the court determined that, it could be violative of First Amendment speech. That's not what we're behind here. And certainly under the facts of this case, we're not looking at off-label marketing in terms of alleging certain factors that are accurate. In particular, one of the key drugs that were highlighted in this case, Risperdal, it had been approved for uses for schizophrenia by the FDA, and only that use, and yet the company promoted it and sold it and induced others to buy it through kickback schemes and other inducements to treat the elderly who were suffering from Alzheimer's or other forms of dementia, to treat children, and also to treat the disabled. And when you promote drugs for purposes that they are not intended and have not been approved by the FDA, we don't believe that's a violation of the First Amendment. Anyone?
Off-label marketing, that's exactly what it is, isn't it?
This is promoting drugs. What we're prosecuting is promoting drugs for purposes that have not been approved, that have not been shown to be safe or even effective, and that's what this case is about. Thank you.
The statute requires that for intended uses, the labeling for the drug provide directions for use and reflect any restrictions that the FDA requires. And what we're talking about in this case involve promotion for intended uses without the required instructions for use that the statute mandates. And so that's the nature of the claim here.
Mr. Attorney General, there are obviously lots of questions about the shooting at LAX on Friday. Just wondering what the latest, your understanding is of the investigation, and do you think there were any things that could have been done to have stopped this, and how do we stop this in the future?
Well, the investigation is obviously underway, and a part of that investigation will be a review of the security measures that were in place, not only at LAX, but I think a review of the security arrangements that exist in other airports as well. The function of the TSA is to ensure that people can board planes safely, take flights safely. The responsibility for protecting airport security is not a TSA function, but something that I think we need to certainly examine given what happened in Los Angeles.
Do you think it's fair to say that a sort of anger at the government was behind this attack?
I mean, this is one of the things that we'll have to try to determine as part of the investigation. There have been some preliminary things that we are learning and that have been reported, but we have to get a fuller understanding of the person who we now have in custody to understand what his motives might have been. Whatever those motives, it certainly doesn't justify what occurred. The brave TSA agent who was killed, others who were injured. No feelings about the government can possibly justify those kinds of actions.
Your department's scheduled to go to trial in 3 weeks over the merger of American Airlines and U.S. Airways. Can you give us a sense of how likely it is that you will settle that case before it's brought to trial, and what's the status of the negotiations?
Well, this is a matter that we have been in touch with the industry, the airlines that we've sued. We've expressed concerns about the potential reduction in competition that the merger would potentially impose. I'm not going to go into any detail with regard to the discussions that we are engaging in, but I will say that they are ongoing. But what we have tried to focus on is to make sure that any resolution in this case necessarily includes divestitures of facilities at key constrained airports throughout the United States. That for us is something that has to be a part of any resolution. So as I said, the conversations are ongoing, and we hope that we will be able to resolve this short of trial. But if we do not meet those demands that we have, we are fully prepared to take this case to trial.
The complaint that was brought, it listed more than 1,000 different city payer routes. Is what you're saying that you'd be willing to accept a settlement that had, I guess, a substantially lower number of city payers that were part of the settlement where the companies would divest slots?
Well, our concern is making sure that we look at, as we do in all cases that the Antitrust Division brings, to make sure that we bring benefit to consumers. We certainly alleged in the complaint the concerns that we've had, and there are a number of ways I think that we can deal with those concerns. We'll see what the conversations that we have with the other parties bring, but we will not agree to something that does not fundamentally resolve the concerns that were expressed in the complaint and do not substantially bring relief to consumers.
Last question is there like a magic number of slots that you need from different airports like JFK or LaGuardia or D.C.?
Yes, there is, but I won't tell you what it is.
Mr. Attorney General, a quick question on the surveillance issues. You know, there's been a flap over the last week or two, a very significant sort of furor overseas about U.S. surveillance practices. As I understand it, about 80% of the work agencies like the NSA does is actually outside the U.S. and is basically ungoverned by statute. It's governed largely by guidelines that either you or your predecessors have put in place. Are you looking at whether those guidelines provide any protection for foreign nationals or whether there's sufficient protections, if any assurances can be given to people abroad that this government isn't just willy-nilly rummaging through their communications?
Well, as the President has indicated, and I think he's totally right, we are in the process of conducting a review of these surveillance activities to make sure that we're striking an appropriate balance between keeping the American people safe and our allies safe, and also guarding the civil liberties and the privacy of those same people. So we're in conversations with our partners in Europe and other parts of the world to make sure that we strike that appropriate balance. There are some fundamental questions I think that we have to ask ourselves. Simply because we can do certain things doesn't necessarily mean that we should do these things. That's I think in some ways the chief question that has to be resolved. Almost a cost benefit. What is the benefit that we are receiving? What are the protections that we are generating against the privacy that we necessarily have to give up? That review is underway. It's a thorough review. The President is fully engaged in that review, as are other members of the national security team, the intelligence community, and I would expect that in a relatively short period of time we will have announcements to make in that regard. Let me just emphasize one thing. The concerns that we have here are not only with American citizens, and I hope that people in Europe will hear this. People who are members of the EU, nations that are members of the EU, our concerns go to their privacy considerations as well. So we're looking at this in a very holistic way.
Can you help the average taxpayer understand why a healthcare fraud investigation and also a banking investigation might take so many years? As Zane mentioned, the complaint in this case was back in 2002, almost 10 years. Can you help the average person understand why it takes so long to get to here?
Well, I'll let them maybe speak specifically about this one, but my own experience is that these are complex investigations that require huge amounts of research, lots of documents that have to be reviewed, great numbers of people who have to be interviewed. They frequently cross jurisdictions, and at the end of the state lines, even federal jurisdictions. And one of the things that you want to make sure is that you investigate these things as thoroughly as you can to make sure that you understand in its totality the harms or the potential harms that have occurred, and hold accountable the corporations, the institutions, and all of the individuals who you possibly can. I don't know if you all want to.
But is there a fear that unless someone goes to jail, particularly a leader, a CEO, that this will just be viewed as the cost of doing business, as Mr. Dellaray and others have testified?
No, I think that given the magnitude of the settlements that we extract, and also the ongoing nature of the monitoring that is done, that is a part typically of these resolutions, that conduct and cultures tend to change in these companies, and we, as I said, we work through these to make sure that that which happened in the past does not happen in the future. I don't know if you all want to add anything.
Maybe. I mean, I think the only thing I'd add is I think what you've seen
in the last 4.5 years, increasingly from this Department of Justice and from this Attorney General, is in settlements like this and resolutions like this, non-monetary provisions which seek to change corporate behavior. So, you have some very specific provisions here that talk about changing the compensation model for the sales force, about changing some of those incentives to actually try to change behavior. Obviously, the magnitude of the fine and the penalty sort of speaks for itself, but in addition to accountability, I think we are looking for deterrence. Factual statements, oftentimes, here you have a guilty plea, of course, but in those fully civil-only kinds of settlements, you'll have an acknowledgement of facts oftentimes. And so I think as we think about how best to resolve these types of cases, we are looking for ways that will change behavior as well as demand accountability.
One more question.
Would you give us an update on the discussions with J.P. Morgan, Chase? We were expecting a settlement perhaps to be announced very quickly, but it appears there are some sticking points. Can you tell us what those are and what the prospects of resolving them soon?
What time frame were you expecting? Soon. Well, that's still an operative phrase. The Associate Attorney General, Tony West, has been leading our side in connection with these conversations. They are ongoing. I think they have been productive. I don't want to get into the nature of what we have been talking about other than to say that I expect that one way or the other we will resolve this soon. We'll either have an agreement or we will be filing a lawsuit.
Perhaps Tony can elaborate.
Tony, you want to elaborate? We're not in a position to announce anything today.
Thank you. Thank you very much.
Well, hold on. Are there other questions?
Yes, Mr. Attorney General. I can't help but note that it was almost 4 years ago to the day that you were at this podium and announced your decision in the KSM case. It's 4 years now. Obviously, it's a military prosecution that's taking place. Do you still stand by your decision then? And do you think that the prosecution would have been over by now if this was in a civilian court?
Well, I think that's actually a good question to ask. And I think that what we have seen over these past 4 years, not to be egocentric about this, but that I was right. I had access to documents, files, recommendations by the military, U.S. Attorney's offices in the Eastern District of Virginia, as well as the Southern District of New York. And I think the decision that I announced on that day was the right one. And I think that the facts and events that have occurred since then demonstrate that. I think that had we gone along the path that I announced at that time, we would not have had to close down half of Manhattan. It wouldn't have costed $200 million a year, and the defendants would be on death row as we speak. We unfortunately did not go down that road, I think, for reasons other than those connected to the litigation, I think largely political. The opposition was largely political in nature. And I think this is an example of what happens when politics gets into matters that ought to be simply decided by lawyers and by national security experts.
Which brings me to Libby, who is being tried in the federal court. How long do you expect that trial to last, and what are your expectations for the case, and anything you can share about it?
Well, that's a pending matter, so I want to be careful about any comments that I might make. Obviously, charges have been filed, very serious charges. The defendant has been charged with participation in a worldwide conspiracy that has a number of separate acts, including the bombings of our embassies. It is our intention to hold him totally accountable, as we have others who were part of that conspiracy. And I think that the process that we use to get intelligence from him and still have a viable Article 3 case is an indication that the Article 3 system is a very effective tool at holding people accountable and at the same time getting intelligence from people who possess it.
How long do you expect this process to last? KSM has been now 4 years, if not even longer. Do you expect it to be just as long or half the time?
So just as long as?
KSM.
No, I think if you look at the history of Article 3 prosecutions, you will see that they don't take nearly as long as those that occur in the military system, which is not to say that some cases should not be brought in the military system. As I indicated on the day that I announced the KSM determination, we've heard some to the military commission process. But I think if you look at the hundreds of cases that we have brought in the Article 3 courts, we've shown that we can be effective, we can do them relatively quickly, and that we can get the results that are consistent with the facts. We hold people accountable. We hold people accountable.
Since you're taking questions on a wide range of topics, on the Boston Marathon case, is the Justice Department going to go for the death penalty in that case?
We have a process that we have to follow, in that we have the United States Attorney from Boston who was a part of that process. A recommendation will come from the U.S. Attorney. We'll go through our capital case review committee. We'll go through the Deputy Attorney General, and finally will come to me before I make a determination as to whether or not we would seek the death penalty. And that process is ongoing.
Have you made a recommendation, Ms. Ortiz?
The process, as I said, is ongoing.
Mr. Attorney General, why haven't civil charges been filed against George Zimmerman yet, and what is the time frame for an announcement or decision?
Well, the case of George Zimmerman and what happens there, I think in substantial part was resolved in the case that was tried. The investigation or the inquiry, the review that we are doing is still underway. I'm not sure exactly how much longer that will take, but we will, when we get to a point where we are able to make a determination, we've tried to construct the case in such a way that we'll be able to share as much information, not just make an announcement, but to share as much information as we can with regard to that determination.
Okay, one more?
Okay, one more.
There's a Senate hearing this week on prison reform. What would you like to see the Senate, what would you like to see Congress pass to change the way the U.S. prison system operates?
Well, I talked about this, I guess, at an ABA speech in San Francisco in August. And I said that the system, I thought, was broken. I didn't mean to imply that I was only talking about the federal system. I think the problems that we have go much further than that. And I think we need to come up with ways in which we hold people accountable, but we also need to come up with ways in which we prevent people from becoming involved in the criminal justice system, deal with people who have deficits and who are in the system so that they can be made better and then ultimately released and to become productive citizens. And that's why I think we need to focus on reentry efforts as well. We also need to have sentences that are, I think, consistent with the conduct that a particular defendant is convicted of. I think there's been a tendency in the past to mete out sentences that, frankly, are excessive. And at this point, given the resource constraints that we have, and as I look just at the Justice Department and the amount of money that the Bureau of Prisons consumes, we have to really rethink our priorities. We never want to put at risk the safety of the American people, and some states have shown that you can come up with, I think, pretty substantial reform, keep the American people safe, and do things in a way that's different. And I would hope that Congress would look at the experience of the states, look at the proposals that we have made, and make those 21st century changes that I think are really needed.
Thank you very much.
Thank you.
A quorum call in the Senate here. Lawmakers today are working on non-discrimination legislation for LGBT employees. A test vote is scheduled for later today. That's scheduled for about 5:30. Also at that time, votes on 2 judicial nominations. On this morning's Washington Journal, we looked at the housing market. While we wait for senators to come to the floor, we'll show you some of that.
In this segment of the Washington Journal, we take a look at how your money is at work in a different federal program. And this week, Wall Street Journal reporter Nick Timmeros joins us from New York to talk about the Federal Housing Administration, which for the first time in its 80-year history asked for and received a transfer this year from the Treasury Department to stabilize its financial position. The transfer came out to about $1.7 billion. Nick Timmeros, for those folks who may not be familiar with the FHA, what is it and why did it need these funds?
So the Federal Housing Administration is a major guarantor of mortgages for single-family homes in the United States, and it's played a small role in normal times. It's played a really important role, a very large role, over the last few years, really since the housing bust deepened beginning in 2007, when private mortgage capital retreated. The FHA went from being a very small player during the boom to a phenomenally large player during the bust. And so if you've gotten a mortgage over the past few years and you haven't had a 5% or a 10% down payment, there's a really good chance that your loan was actually backed by the FHA. The FHA doesn't make loans, but insures loans that meet its standards, from banks, as large as Bank of America and Wells Fargo down to your small local bank or credit union. And so they've played a really important role keeping the housing sector afloat, really, so that people could still get mortgages and buy and sell homes. They ran into trouble because they only require a 3.5% down payment. And so from 2007 to 2009, when home prices were falling, they made a lot of loans, riskier loans, and when people lost their jobs and they had they lost all the equity in their house, so they had nowhere to go. They couldn't sell their house. They ended up in foreclosure, and the FHA has sustained some really incredible losses on those loans.
And so, is this the FHA paying for 2007?
Initiated.
Without objection.
Thank you, Mr. President. Mr. President, I just returned from spending the weekend in my home state of Wyoming, traveling around the state, visiting with people in Natrona County, in Casper, as well as in Rock Springs.